Yes.
Any mention?
No subsidies.
Please, my lord. I beg to mention item number 22, my lord. Pray for 3 weeks' time.
You're the petitioner or respondent?
Respondent number 4, my lord.
Petitioner.
Should we mention that there's a PIL?
We've just learned there's a PIL which has been registered on 6 of 24.
With regard to?
Meant to do river, my lord.
River itself. With regard to the same river in Gentiles.
River, Mintru.
Meant to do river.
This is the same, 22 concerns that only.
Yes, my lord.
Okay, in fact, I had occasion last week to go and it's really deplorable, the condition. What to do? You want? Listed together PIL?
No.
Who are you appearing for? Who's your senior?
AG Mohan.
What to do, Mr. Shongwan?
When me also, my lord, I don't.
It may come up after 2 weeks, my lord. We'll
Let's
see
count
what
2
it
weeks
is.
to see
the
what
outcome
the
of the
outcome
PIL.
is.
Lord.
Yes.
Obliged, my lord.
My lord, similar prayer for item number 25, my lord.
25.
Yes, my lord.
No objection, Your
Pray
Lordship.
for 3 weeks' time.
See,
Oh, my lord.
4 weeks, yes.
Much better, Lordship.
May it please the Lordship. Lordship, I beg to mention item number 17.
17. Yes.
17 to 19 are connected, Lordship.
Yes, sir.
Only,
Yes, yeah, he's been told he's in hospital.
There's no problem, but only one request, madam. They can intimate me 1 day before I don't
Yes,
take
at
the
least
journey
you
to
intimate
Shillong,
them.
my lord.
At least it's courtesy, your
That
senior
much,
is
madam.
not well.
Last occasion I was here, it was mentioned without informing me. This occasion I'm not having any, but they should at least
17
mention.
to 19.
Yes, Lordship.
Yes.
Correct.
After 2 weeks.
Highly obliged.
Yes.
Obliged.
You take a date, Mr. Mandar. Yes.
Lordship, I beg to mention item number
Number?
16, Lordship.
You're for?
Respondent number 6, Your Lordship.
Who's your senior?
Expanded, Your Lordship.
Why? What's the matter about?
This is with regard to the
Salary and allowance, Lordship.
Why he did not want to do the
He's
case?
on his leg, Lordship.
Doesn't matter. We'll call it out. Yes. No excuse that's on his legs.
Yes, Your Lordship.
Yes.
Your Lordship, actually this matter is being handled by Mr. H. Hazarika. He's
Which
not
one?
available. The same matter, item number 16.
16.
Your
Where are you gone?
16,
16 years.
What's happened to Mr. Karwana? Again, he's sick. After 1 week, yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 23, Your Lordship. Does the matter could come after 2 weeks, Your Lordship? 23 now.
20.
23, Your Lordship.
After
2 weeks, Your Lordship.
No objections, ma'am.
4 weeks, yes.
Aye.
Why, which take 5 weeks.
4 weeks.
You won't have to problem of mentioning it again. Yes.
Your Lordship, similar prayer for item number 27, Your Lordship.
27. 4 weeks, yes.
Much obliged, Lordship.
Yes. Follow, yes.
Daily list, item number 1.
Cognizable offence for which they want to do investigation with the meaning of section 165 CRPC? The answer has to be no, because in the affidavit nothing has been disclosed regarding registration of a non-cognizable crime. Now, in case of a cognizable offence without the approval or permission of the magistrate, they cannot go. Now, in the permission of the magistrate, they cannot go. Now, in the affidavit, it is the affidavit filed by the Superintendent of Police, one Mr. D.S. Rathore. If the Lordship will kindly come to subpara Roman 10 of para 7. There they explain the position. At
Yes.
page 7, may I read it, my Lord?
Yes.
It is submitted that pursuant to the complaint on 5th of July 23, UB Inspector Anmara, Circle Inspector Sadar Tura, respondent number 4, along with Nazia Z. Momin, and other police personnel went to the residence of Srimati Sumati De at house number 2 Fancy Valley Tura and found the complaint to be true. The officer requested the petitioner to inform petitioner number 2 to discuss the matter instead of cooperating with the police officer. The petitioner number 1 started misbehaving and charging them. It is submitted that since the complainant Srimati Sumati De is 64-year-old lady and a widow, she had to hire labor as well as police personnel, also had to assist in breaking open the lock and to dismantle the CCTV cameras which are installed without her permission. The entire inquiry was conducted in presence of Sumati De, the parents of the building. 11. It is submitted that from the series of affairs and complaints as stated above, it is evidently clear that the petitioners have been all along harassing the house owner as well as their own family members, creating nuisance and menace to the other residents of the neighborhood. It is absolutely false and incorrect that petitioners were abused or manhandled on the day of inquiry by police personnel. Despite requests to cooperate with the inquiry, the petitioner refused and in agitation started taking photographs and video only to disturb the police personnel, perhaps with the intention to portray herself as a victim. It is also pertinent to submit that the police personnel never entered the room of the petitioner. It is also noteworthy to submit that the very fact the petitioners were able to obtain video footage from so-and-so installed inside the room of the petitioner shows that the police personnel never entered the room of the petitioner. Inquiry was not illegal or forceful as alleged, and the allegation of the petitioner is true. The same could have been destroyed by the complainant or counsel or seized by the police, but the same was untouched and submitted by the petitioner to the honorable court. A perusal of the footage will also show that the allegation of the petitioner forceful and illegal entry is false and incorrect. In this regard, DD entry was made by DD number 16 that is 24 and non-FIR case versus by Pura PS case number under section 107-145 was also...
Yes, Mr. Kiran Chaudhary. Yes, okay, that's fine. Why harassing this old 64-year-old lady?
There is no question of nobody.
From the prima facie, it looks that you're trying to what do you call it? Overwhelm the entire investigating process. The poor lady who is here, you're trying to browbeat them into submission. This is what is apparent from here. Maybe procedurally there might have been some lapses, but then I don't know if the old lady here, 64 years old, and able-bodied petitioners. Actually, something should be done to redress the situation. Yes.
No, my lord.
Yes.
There is no material on record for your lordship to arrive at that even privacy findings. For the simple reason, we are alleging police harassment.
That's
the
it.
allegation is police harassment. The allegation is not a dispute between landlord and a tenant. If it is a landlord dispute tenant, then one should go to civil court, not to police. Now, my lord, my only submission is, if a 104-145 proceeding has been initiated, which is the statute which confers police to enter the premises and make inquiry without order of the magistrate. That's why I'm saying the entry of magistrate.
No, maybe we'll examine that. We'll examine regarding procedurally. Maybe there are some lapses and latches, but the thing is that from the entire facts of the case show that it's a domestic dispute between some poor old lady and the petitioners, where there's another case also, who's Sumit Jair Bauer, some case registered. So it's, it's not a question of, of a one-off, police atrocity being, committed. So it's not that. But the thing is that maybe we will examine that. We'll examine that part regarding, regarding your allegations of, police excessive use of force and so on and so forth. But basically, what is the dispute about? You tell the court.
Dispute is, maybe there is a dispute of...
What is the dispute about?
No,
yes.
will not give this handle to this police. Please,
no, we're not giving handle. Just court wants to know, to look at the bigger picture.
Police have misbehaved. So my question is, there is no dispute that police came to my premises on 5th of July.
No. Mr. Chaudhary, just for the information of the court, what is the... No, just for satisfying the court, what is the court dispute about? What is it about between these people?
There is no court dispute. No, I am not troubling your lordships to decide the court dispute. I am before your lordships with a very simple grievance. Police came to my place on 5/7/93.
Yes.
Petitioner number 1 is the wife, petitioner number 2 is the husband was absent, and police has abused their authority and created ruckus in my house. I am against that. Lordship is also deciding that if there is a landlord...
Now for that we can...
We'll go to civil court. Now the question is, when they are saying they have registered a proceeding under 107 and 145 CRPC, I am asking them, the respondents, which statute authorizes them without order of magistrate to enter the premises and make an inquiry. Therefore, their entry into my house is unauthorized. Therefore, I am before a constitutional court. I am not against any other demand.
No. We understand that, Mr. Chaudhary.
Yes.
Court's well alive. He understands the grievance of the petitioner regarding unauthorized entry and this total abuse of process, by the police. It's just the court for its own satisfaction wants to, because it's seen that 64-year-old lady, FIR file, so that kind of thing. So what is the exact situation on the ground? That why does the police act in such a way? What compelled them to,
No, Lordship is talking about the poor lady.
Yes.
Lordship is not talking about another poor lady who is on the receiving end.
Two poor ladies. Okay, two poor ladies. Why they come to this situation?
No, my lord, that's what I am saying. Supposing there are some landlord-tenant dispute, I am not disputing that. On ground, my lord, there could be. I am not disputing that.
Yes.
Question is, we are alleging police action. I am only on that. Now, evidently, police now they say they entered. Now the question is, based on what authority they entered my premises? I want to know. They have no answer. They have already stated they have never registered. If they have registered a non-cognizable crime, then they can, for the purpose of investigation, they can go to my house under 165 CRPC. I am not disputing that. That is not their case. Their case is they have registered a DPLP for a proceeding under 107 and 145. My understanding, subject to what your lordship may say, that to do anything in a proceeding under 107 or 145, there has to be an order from the position.
No, Mr. Chaudhary, you made your case. We'll admit this matter for hearing. Only thing is that it's just court wanted to know, to be satisfied as to what are the the other extraneous circumstances that prompted this action. That's all.
Okay,
yes, MS Yangi, anything to say?
Yes. We definitely explore.
Please, Your Lordship. Your Lordship, in this case, Your Lordship, as Your Lordship has been repeatedly saying, an old lady has gone to the police for protection, Your Lordship. And it was the duty of the police officer to go and inquire into the matter.
Yes.
So that is why they have entered the premises. On entering the premises, it was the police officers who were humiliated and harassed by this lady.
But why did you go and break the CCTVs?
CCTV has not been broken. It was installed by the petitioners without the consent of this lady, who is the landlord lady. And so the landlady had already hired laborers. And it was the laborers who had brought down the CCTV, because it was...
then we will examine it, because even then...
The privacy was being...
Paramvasai also, we are talking...
Because
harassment might be there, Paramvasai also...
But your Paramvasai also, Your Lordship, this petition is not maintainable, because there are so many complex, disputed facts to be considered, Your Lordship, that whether this writ petition... They ought to have approached the police or the judiciary, but not before the High Court, invoking the extraordinary powers of this honourable court.
We'll hear it. If we have to pass, we'll pass. Yes, heard Mr. Kinchoni, senior counsel, assisted by...
I have a small submission.
Yes.
Case is not maintainable, my lord. If my lord, they are alleging some harassment, my lord, what prevented them to file my lord? There is a total different procedure altogether, my lord.
We'll hear you.
Can these matters be decided otherwise, my lord?
Yes, we'll run for hearing, because there's certain things there which the court has examined. Maybe you have to call for other records also. That's the only thing, because the GD entry has been made. Has that been annexed here?
And my lord, the premise...
Yes, it has been annexed.
And my lord, the premise does not belong to the petitioner, my lord. Petitioner is only the...
We're not going to go there. That's why this court wanted to know what's the larger picture with regard to why did this situation come about.
Lord, as far as the CCTV, my lord, it is installed just next to the toilet bathroom, my lord. Well, what is the requirement of installing a CCTV there, my lord?
Yes. We'll hear early date. Yes. Maintainability question we kept open. Yes. Heard Mr. Kincholi, senior counsel, assisted by so-and-so. Also heard MST Yangi for the respondent number 1 to 3 and for the respondent number 4.
Yes.
Yes. Stop. Upon hearing the counsel for the parties, matter deserves further consideration and as such admitted for hearing. The question of maintainability, however, will be left open. List, when?
After 2 weeks, Your Lordship.
After 2 weeks we'll hear it. Yes. After 2 weeks.
My Lord,
Yes.
Item number 2.
Your Lordship, I'm praying for some time in this matter. Mr. Paul is having some medical urgency in his home. So,
Mr. Chakraborty walked in the rain just now, I saw, when I was coming to court. How will you compensate him for his toil and labor? We'll fix matter today.
Lordship.
Because in this, they have now raised the point that there is no arbitration.
We'll address that. Just as that we need Mr. Paul to be standing here.
Yes,
that's all.
that's what.
Lordship, his mom is not keeping well. So
Yes, it's all right. It's list after 1 week. He'll be
next week, Your Lordship.
Yes, as the Learned Senior Counsel on behalf of the respondents unavailable due to urgent personal work, urgent personal matters. This is matter after 1 week. Yes.
Highly obliged.
Item number 3.
Ready for evidence today? Huh?
Your Lordship, we have filed an adjournment application, Your Lordship, in this matter.
You're not interested, then you might as well withdraw it. What's there? Just pay a small cost to legal services. Or withdrawal in election process also, election matters also is a serious matter. But you would consult your client. Because election petition, in the heat of the moment, you feel that you've been wronged and you run to court. And after it runs through course, just 1 year, like they say, all air is gone. Take instruction, yes. So my adjournment for reasons stated there. After 2 weeks, yes.
Item number 4.
And it's always incumbent upon the court to finish the matter within 1 year, but you don't have cooperation, we can't finish it. Yes, MSE 1 year.
I'm praying for 2 weeks' time to file my rejoinder.
How many times you prayed?
This is the third time, Your Lordship.
Third time. Last opportunity granted to petition to file rejoinder, list after 2 weeks. Yes. We'll list for hearing in the meanwhile. Just for hearing in the meanwhile. Yes.
Item number 5.
Matter is fixed for rejoinder, Your Lordship.
Sure, I'm praying for some time.
Or 7 to 10.
7 to 10, Lordship. From Manipur, we had tried getting.
You file your affidavit.
We file, Your Lordship.
Manipur submits that as response number 7 to 10 at service still being awaited. Stop here. However, submits that the rejoinder be filed within
2 weeks, Lordship.
Within 2 weeks. Stop next paragraph. Lists the matter on so and so for rejoinder affidavit and for service report on response number 7 to 10.
Hello.
Item number 6.
Respondent number 2 and 4 have filed their affidavit, my lord. And in this
4 or 2 and 4?
2 and 4.
2 and 4.
No. 3 has not filed, and the
But
2.
then it shows that you're appearing for 3 also.
Yes, Your Lordship. Before he advances his submission, Your Lordship, I just want to clear some my submission that, Lordship, admittedly there have been some lapses. There has been some miscommunication. There are also instances where some documents also is misplaced. And fortunately, it's been retrieved now.
Yeah.
So basically, Your Lordship, if you see at my affidavit, Lordship, come to
page 14.
Page 14, Your Lordship. This is the recent letter, Lordship. It's dated 24th April 2024. So now they have asked us to resubmit both halves of the PPO. Lordship, we are under process of that. And Lordship, if you see, you come...
when did the person retire, petitioner?
My lord,
Yes, sir, Mr. Karunan.
Then, Lordship, if you come to page Annexure 6.
There's a pink pensioners portion.
Yes, sir. This is the pension payment order. This was submitted by the sister, petitioner's sister, on 28 May 2024. So we have just got this, and everything is under process.
How much
so what
time
my
will it
humble
take?
submission is, Your Lordship, if you give us 3 months time, I'll try to work out on this, and we'll make sure that the pension payment order is released to the petitioner, Lordship.
Yes, Mr. Yobin. He's acceding to your request.
It's just 3 months time, because there has been some communication gap. That's why, Your Lordship.
3 months would be, my lord, the ground situation is I'm a student, my lord, and we are both orphans. My sister also can't do much. We are surviving because of this, man. So,
so you advance a loan to her from your pocket.
My lord, I need lord. So anyway, my lord, 2 months, my lord, 3 months would be little. If
do it within 2 months.
Yes.
I'll try my best. I'll try my best.
At the outset, when the matter is taken up, Mr. K. Karmoplang, learned counsel for the respondents 2 and 4, has submitted that the delay in which is with regard to the return of both halves HLBS of the pension payment order in respect of the late mother.
Sister, this is a sister, elder sister.
She's died also, elder sister?
No, she has become overage.
Oh, in respect of the elder sister, MS MEELEVA Lingdo. Meeleva Lingdo. Stop. Learned counsel has also referred to the pensioners portion of the pension payment order and submits that the same has just been received on 28 May 2024. Stop. In these circumstances, he praised that as the pension of the petitioners only to be processed, the response may be allowed 3 months' time to complete the same stuff.
Obliged, Lordship.
Next para Mr. B. Oben for the petitioner, however, submitted that as the writ petitioner is in dire need of financial aid, he praised that the respondents may be allowed a maximum of 2 months. Stuff. Considering the nature of the case and the time required, 2 months' time is allowed to the respondents to complete the process and for release of the family pension to the writ petitioner. Should we dispose of the matter?
Dispose of the matter. Only, my lord.
In view of the discussions about matters so stands disposed of accordingly.
My lord, actually that's become due from March 2021.
They will settle in.
And by now the interest must have accrued to that also, my lord. So they must not deny the interest, my lord. But finally, they might blame on me because
you can raise that. You can raise
my lord. Obliged.
Item 7.
Yeah.
This case will be filing in the course of the day, Lordship.
You're for number 5. What about 6?
Respondent 6 has been recently included as a party, so we are waiting instruction.
Who's respondent number 6?
It's a government secretary to the government Meghalaya personal department.
It's already come twice. Last time SRE Nonkari made the exact same prayer that you're making.
That is the same situation at this moment. We have not received any instruction.
Yes, Mr. Karmoplang, on behalf of respondent number 5, submits that the affidavit will be filed in the course of the day. Stop. MS Arakolni, on behalf of respondent 4, 5, and 6, submits the instructions still awaited. She prays once allowed for the 2 weeks' time to file affidavit. Yes, this is thereafter.
Obliged.
Let's proceed.
Item number 8.
May I please, Your Lordship?
Lordship, in this matter, we are still awaiting instruction from the department.
Yes.
On behalf of Mr. Sheikh, my lord, he is on his instruction and they have not yet.
Yes, this has to wait for the 3 weeks time allowed to the respondents file affidavit. Yes.
Thank you, Abhishek.
I'll oblige.
Item number 9.
May I please, Your Lordship? I am awaiting instruction, so I may be granted 2 weeks' time to file the reply.
What is the matter of our pension?
Pension matter, Your Lordship.
Which department?
Forest Department.
Forest Department.
Forest Department.
MSE Pasa for 4 submits the affidavit on behalf of settled in the course of the day. So FC Brashaji prays for the 2 weeks time to file affidavit. This after and so on. So.
10.
Much obliged.
Yes. Was it for today?
The last occasion, senior counsel had short time because he just received a...
No. Last time short time on your on your
I
account.
was not there. Sorry. Apologize.
Unless you designated yourself as senior
No,
counsel.
no, I was referring to senior counsel second time.
Yes.
In this matter, the respondent has not filed a counter affidavit.
You have not filed?
My
There's no
lord,
counter
I have filed an application for vacating the interim order, and I would like to rely on that, madam. Because the district
And
council
Mr.
has jurisdiction.
Lordship, I am not filing, but the mind of the court is that this matter can be remanded to the executive committee
Yes.
to hear the parties.
Ilaga Act 1991
Act is a market act, correct?
Yes, market.
Do the market. Yes. Yes, Mr. No, pure. Where's the impugn order?
Impugn order will be at page 20 of my writ petition. Lordship, the case of the petitioner is that there was an auction notice.
Settlement?
Lordship, my settlement will be at page 15, Lordship.
Page?
Page 15.
Page in settlement. Is auctioned by whom?
This is auctioned by, the market was initially auctioned by respondent number 2.
Is it a private market or is it a
It's a
steamship
private
market?
Private market.
The private market.
Lordship. It has been auctioned by the market committee. That is the respondent number 2.
Where's the notice for auction?
Notice of auction will be at page 12, Lordship.
It's 28 March.
28 March.
24. Then you were successful. Second for 2.5 lakhs. Yes, that is A2. 24.
So I was granted license to operate the market for a period of 1 year, Lordship.
8, 4, 24, 2. Then what happened?
Then after that, Lordship, surprisingly, the respondent number 1, who is the AM, he had re-auctioned the same market in which I have been settled with. That is at page 20. I'm before your Lordship challenging this notice. Same auction notice, re-auction notice.
Okay. Now, what's
Lordship, I'm
next
done.
3?
Next chapter.
You're just doing well, Palyar.
Lordship, file a caveat before the district council in the event if there's any challenge to my settlement issued notice.
Yes.
That is the application at Annexure 3. Now the
And
same without challenging my settlement, the same without challenging the license issued to in my favor, he had issued a re-auction notice, which is at page 20, Lordship.
Annexure 4, impugn order.
This is the impugn auction notice.
This is Annexure 4.
Lordship.
Auction 25, 424 says, yes.
My contention is that, Lordship, this is a private market. The same has no authority.
Established by whom?
This is by the clan, Lordship. And it's run by the Omdulan market. Private market is defined at...
Where's private market? You have, okay, at para 2, section 2, 2E District Council markets, 2...
N is private market.
M.
N,
New
N.
market.
Private market. N. Now the
Private
management...
market, what just read it?
Private market means a market established by and under the management of an individual or group of individuals working together, or a firm or municipality, a town community, corporation or department under the government and recognized as such by executive committee.
Is recognized by executive committee as market.
Lordship, this is not just a... It's been there for quite some time, Lordship.
But one thing...
Lordship, another... Lordship, kindly come to S, Lordship.
To S.
The management.
Yes.
Lordship, the market is known as the Omdulan Market Committee.
To N private market, to S is management. Okay. Right.
So the respondent number 2 is the market committee established under this Act, Lordship. Lordship, kindly come to section 8.
Yes.
Section 8, subclause 1, private markets. Kindly come to A first, Lordship.
A.
Elaka markets shall be managed by the chief together with his darbar.
Right.
B. Right markets be managed by the same right, or as the case may be, the Sardar right or headman of a Sandhi together with his darbar. C. Private markets shall be managed by the owner or owners thereof, or by an agent appointed by them, duly recognized by the executive committee.
Yes. So 8.1c. So private markets.
Private markets.
Now, where's settlement?
Lordship, the settlement will be 11, Lordship.
Yes. So at the time of auction, was any officer of the council available?
Lordship, there was a permission granted by the district council.
Where's the permission?
To auction the market. That will kindly come at page 12, Lordship. Page 12 of the repetition, the first auction notice.
Page
12. Lordship, there's a reference to that permission in this notice.
Is it type copy here?
This is the type copy, Lordship, translated copy. Page 12, Lordship.
Page 12.
Lordship, annexure 1. It is hereby notified to the public that the office of so-and-so will auction the Omdulan market on so-and-so at so-and-so at the reserve price.
Where's
just below this same paragraph, Lordship.
Where's the letter?
Lordship, I'm referring to this.
Where's the 22nd March 24 letter?
Lordship, this is I'm not in possession of that because I'm just only the bidder, Lordship. I'm not the market. So by this letter, the Lordship, there was a permission granted to the committee, which is the respondent number 2, to auction the market.
You don't have a copy of this letter? You must be having.
I don't have a copy, Lordship.
Don't have a copy.
It's there in my show cause.
Oh, you're there also. You're for respondent number? You're the?
He's representing market committee.
runs the market.
Okay, we'll look into that, yes. Okay, so now, you see, as per the regulation, that means permission was there,
Lordship.
and then it's a private market.
Come to section 21, Lordship.
Yes. Yes.
Any aggrieved party, they can approach the district council, Lordship.
Right, okay.
So in my submission, Lordship, the
If they
auction
agree, we should have gone there.
should have gone there.
Okay.
Not issued a fresh notice.
Yes. Okay.
And so far, this is a private market, Lordship. The same has no jurisdiction over the market.
Yes. Yes. So, in your case, that for you, there's no point going to executive committee also. Why you didn't go there? If this is a legal order issued by the same?
Lordship, there's no order from the same.
Is
It's
the
an auction notice.
Exactly.
Notice.
You have made a complaint. In the
Lordship,
auction
my
notice.
right have been
If you
curtailed.
already, if you say that under the permission came to executive committee, your market, the management has auctioned the market.
Lordship,
You are the
here
successful
the
bidder.
question is a
And so
jurisdiction.
now, if an auction notice comes out, isn't it your duty to say that this is created a sort of a confusion, and then you file a complaint against this EM before the executive committee?
Lordship, my market has been, Lordship, the market.
Of course. Yes.
I'm challenging the illegality of the auction of the
Okay, yes.
issued auction
Yes,
notice.
Mr. Chandraso, here for?
Let it, special
Yes,
counsel
oh,
is
let the
denial.
special counsel.
Yes.
Yes, Mr. Kanta.
There being a special provision, specific provision for alternative remedy, I think the writ petitioner should have approached, as the court have indicated, before the executive committee. I think this matter can be closed, Your Lordship. Let them approach the proper forum.
That's it.
That's all, Your Lordship.
Yes.
My Lord, my short submission is the...
Where's the application?
My application we filed on 22nd May, my Lord. Application number 83.
Application number?
83, my Lord.
What are the grounds for...
My Lord, we come to what happened in the background. The link
Oh,
was...
you didn't make this council party earlier. Why?
Lordship,
Why didn't you make a council party in the...
That is why.
it has been completed
They
later
obtained
on.
the stay order behind.
Yes. Yes.
My Lord.
What is
The
the submission?
link was suspended, and during the mortgage is, my Lord, mortgage...
Who was suspended?
The link of the Glen. The link
Who's
the link of Glen was suspended on 4th July 2023. Now the system is, my Lord, the mortgage is managed by the committee headed by the Lingdo. So the moment
Lingdo was suspended
on 4th July 2023 by the chief.
4th July 23.
2023.
Who's the Lingdo?
The Lingdo...
He chairs the management committee.
Yes, he's the chairman of the
So
market
you mean
committee.
to say that settlement by a Lingdo has been suspended?
Yes. Lingdo-ship. There was a market committee, and the private respondent, my friend, other friend, he was claimed as a secretary. The moment Lingdo was suspended, there was no more market committee. Now what happened? Suspended, there was no more market committee. Now what happened? His suspension was a challenge, and during the pendency, the private respondent proceeded, approached the district council, obtained the consent. Behind the back of the Lingdo, acting Lingdo. Behind the back of the Lingdo, acting Lingdo. Now the acting Lingdo appointments were challenged before my friend before this court, and they obtained the stay. They obtained the consent from the district council.
While he was suspended?
Yes.
The district council was not aware that he's a suspended Lingdo?
My Lord, he was suspended by the chief. Then what happened? He obtained and he proceeded the auctioning, where the private respondent has auctioned the market, and writ petitioner participated and he was given the contract. Now the resident came to know this, therefore the filed objection before the district council. District council has a stay the permission given by district council to the respondent number 5, the private respondent.
Where is that document?
May I just, in my application document, kindly see,
yes.
Page number 32. 32. 32 is the permission obtained by the respondent, 22nd March 2024.
So you mean to say that this SL Palyar is suspended, Lingdo?
Yes. Yes.
Where is the suspension order?
My Lord, it's not, my Lord, annex here, but the order passed by my Lord is there. We have annex in that case. The final order passed by this Honorable Court is annex here.
Where is the order?
Well, page number 65.
Sure, it's not as what it appears. The case is not so simple as what you tried to make it out to be.
Lordship, I'm a bidder.
You're a bidder?
I participated
You're
in
a
the
bidder,
bidding.
I heard, sorry.
I participated in the
Yes.
bidding process. I don't know what is
Yes.
the dispute between the
Yes.
respondents.
You understand, yes.
Order was 22nd April.
Yes.
And this was the final order passed in that case. And Lordship kindly see para 4, page number 67. It says, in the intervening period, should any issue arise with regard to the matters within the said clan, the same shall be referred to respondent number 1, that is the chief, for clarification or decisions. It is further provided as in the complaint itself, the name of respondent number 2 had been suggested to be the acting lingdo, which was exceeded by respondent number 1 at that time. The said reasons shall no longer function as the acting lingdo till disposal of the inquiry and order passed thereon by the respondent number 1. So during that inquiry pendency, chief was allowed. Now, when that pendency, the inquiry was pending, the complaint came. Therefore, chief has issued the auction, and my friend has challenged it. Now, may I take the council permission, page number 32. District council permission granted to my friend respondent number 2 in the repetition.
Yes.
Page number 32. So respondent number 2 obtained this permission from District Council on 22nd March.
Yes.
He was a nobody. There was no market committee. Acting lingdo was there. Behind the acting lingdo, he obtained this order from District Council. Now, page number 33, there was a complaint by the acting lingdo. Page number 33,
Yes.
on 1st April. And on the basis of that complaint, with regard to auctioning, District Council page number, my Lord, 37, has revoked the permission. My Lord. My Lord, page number, I'll see. My Lord, page number, I'm sorry, stand corrected, page number 39. Page 39. District Council has its own order, consent order.
It was dated 9th April.
Yes, 9 April. So my humble submission, my Lord, the petitioner should have filed, should approach the District Council, which is efficacious remedies there available for him.
When did you come to court?
So I filed the petition on 2nd May, Lordship.
Were you aware of this order?
Lordship, no, I'm not aware, Lordship. Lordship, this letter is not even addressed to me, Lordship.
Yes. No, I'm not saying addressed to you. Were you aware of the letter?
This is the first time that when they filed the affidavit, Lordship.
Have you filed a reply to the...
I filed a reply to this, Lordship.
Yes,
And,
Mr.
Lordship,
Nobri.
I want to make one submission on this, Lordship.
Well, let him see him first.
I'll reply.
Yes, Mr. Nobri, what do you have to say? Yeah?
And the management committee, duly
Where's your affidavit?
authorized by the, filed by show cause in
The miss case?
this case.
Okay. Yes. What's your case?
My case, Your Lordship, I've been duly authorized by the clan members to run and operate the market in my Annexure 1, Your Lordship. It's page 15. This is
18, this one.
Yes, Your Lordship.
Then?
And thereafter, Your Lordship, on 16/1 in Annexure 4, page 28, Your Lordship. This is a meeting of the... By this, Your Lordship, I have been authorized to approach the District Council for necessary permission.
No, but I suspended.
No, Your Lordship. I'm the acting link door, Your Lordship.
Oh, now then the matter is stronger case for, yes. Where have they given you authority?
Lordship, I'll take.
On the basis of the 2018 letter?
Yes, Lordship.
Who's the one who suspended? Name?
Stupanli Palyar.
Suspended?
These are suspended link door.
Yes.
Then this 18 gives you Stupanli Palyar?
No, Lordship.
That means Stupanli
different
Palyar
person. It's different
only
person,
was
Your
given the approval by this Court Palyar, like
I'm the
to run the market.
Yes, I'm Spider Palyar, Your Lordship. I'm the secretary management.
See, that time you were suspended on 4th of July 23. Then why did you chair this? The Annexure 4 says that the meeting presided by Chairman Steve Stupanli Palyar. If you see suspended since 4th of July 23, this is 16/1/24. Then how, what authority?
I'm Spider Palyar, Your Lordship. I'm the newly secretary, Your
So
Lordship.
you read Annexure 4, Mr. Nombri. Read the second paragraph.
The member of Umdolan, Lordship, the members of the Umdolan Market Management Committee shall remain till such time and General
No. Read from the top, second paragraph. Presided by whom?
The meeting is presided by the chairman, Shri Stupanli Palyar, and matter discussed are as follows.
Then, how did he chair the meeting when he was suspended?
But Your Lordship, the clan member already authorized the secretary to.
He authorized in
the secretary, not the chairman, Your Lordship.
Where the authorization? Annexure 1.
Annexure 3, Your Lordship. Page 20.
Excuse me.
The proceeding of the meeting of the Palyar Mokoda Laikpo.
Then you go before the committee, let them settle it.
This is 15 January 24.
Anything else to say?
Your Lordship, thereafter, after the auction has been completed, then we were supposed to submit the report along with the supposed to submit the report before the Ilaka market. Then we submit, Your Lordship, but they refused to accept
But the
on the basis
now
of the
there's existing order existing with regard to the stay of the.
No, Lordship.
Of
I'll
grand
clarify
auction.
that, Lordship.
Okay, whatever you clarify won't satisfy. Anyway, what do you have to say?
Lordship, the letters revoking the permission, Lordship, that is dated 9 April 24. I've been settled with the market on 2nd April, Lordship. That letter cannot be even.
No, whatever it is, there exists a dispute. You understand? It's just that there's a dispute that has been you're either receiving end. That's because of your bad karma. So finish. So you have to face the the whatever you have to face.
Lordship is remanding the matter to the market Ilaka, Lordship. Lordship, my only humble submission at this stage, I may be allowed to run the market, Lordship, till the matter is decided by them.
We'll see. Yes, take down. There was no bridge in Ranikon that time. They requires a bridge to reach this place, and this Umdolan market tour. So we came downstream to this place by boat. It was a very beautiful place. And if you sit on top of the ridge of the hill and see market day, these boats zipping down to go to the market. It's unknown, but it's a very, very beautiful place. Yes. Stop. The brief facts of the case are that on an auction held by the respondent number 2, that is the Umdolan Market Management Committee, the petitioner who had participated in the same was successful and was accordingly granted permission to collect tolls in respect of Umdolan market for the period March 2024 or April 2024, 8th April 2024 to March 31st, 2025. Stop. The grievance as set up by the writ petitioner is that on being settled with the said market, which he alleges is a private market run by respondent number 2. The respondent number 1 is the CM. The respondent number 1, the CM also by the impugned auction notice dated 25th April 2024 called for fresh bids for the said market, which had already been settled with the petitioner by the management committee. Stop. We presently settled with the writ petitioner by the respondent number 2, which is the owner of the market. The said auction notice be quashed and set aside. Mr. Emma Nongpur, next paragraph, has also submitted that the on behalf of the respondents, Senior Counsel firstly has submitted that as the dispute in question concerns the settlement of a market, the writ petitioner, if aggrieved with any order or order, is the order of remedy is available under the Khasi Hills District, within bracket, establishment, management and control of markets regulation 1979. Stop. He therefore simply submits that the entire dispute as raised can be effectively adjudicated by the respondent number 1 under the said regulation. Stop. Next parameter, Rachel Changri Sonia, Senior Counsel, who has filed the connected miss case being miss case number 83. Has placed the averments being said miss case and submitted that it would serve also as an affidavit to the main case. Oh no, sorry. The counsel has filed the miss case on behalf of respondent number 1. Number 1. Has placed the application, has read on the application and submits that the averments made therein will also serve to substantiate his stand in the main writ petition. The Senior Counsel has, where was that in this case? Has submitted that though the market in question is managed and run by the management. The same, however, is under the chairmanship of the Lingdo or the Paler clan, who, however, has been suspended since 4/7/2023 by the chief, respondent number 1, and an acting Lingdo appointed thereon. He submits that the Lingdo, who has since been suspended, therefore cannot chair the said management committee, and thus has no authority to settle the market in favor of any person. Stop. To substantiate his arguments, the Learned Senior Counsel has where is that? Has further submitted that the fact that the said Lingdo has been suspended and the matter where's that order? Page High Court.
High Court order. Page number 65. Order dated 22nd April 2024.
And thus has no authority. After that, substantiate his argument that the said Lingdo was under suspension. That counsel has drawn attention to court to
page number 65 to order dated 22nd.
Order dated 22/4/2024, passed by this court in WPC number 214/2023, wherein he submits at para 4. It has been clearly directed that should any issue arise with regard to the said clan, to matters within the said clan, the same shall be referred to point number 1 for clarification. So therefore submits that the subject matter, the matter and issue which deserves the consideration of the respondent 1 was never brought to his notice, and therefore the impeding order was issued in this regard. It is further submitted that by order dated, where's that? 9? That order whereby the auction has been stayed?
Page number 39.
Further submits that the respondent number 1, page 39.
39, in my miss case.
Yes.
9 April.
Respondent 1 had also stayed the permission which had been granted on 22nd March 2024 for leasing out the Eodolan market. He further reiterates submissions made by the Learned Senior Counsel on behalf of HTC and submits that the matter would be better served if the same is taken up as per the regulation. Then Mr. Inombri. Mr. Inombri has said what?
Lordship, against that stay order also, I have filed my show cause, and that is still pending before.
Mr. Inombri submits that Mr. Inombri, in support of the petitioner, has ever submitted that though it is a fact that the said Lingdo has been suspended, but the management continued under the secretary, who was the person under whose authority the said market had been settled with the petitioner. So he therefore submits that the market being private and the management being intact, there's no illegality whatsoever in settling the market with the writ petitioner. Next paragraph. Also for the part. Upon it is seen that, firstly, the fact that any dispute with regard to markets being covered by the market regulation is undisputed, and in such matters, the competent authority to decide the same has been provided in Regulation 21 of the said regulation. There's point number 1, therefore. That's why you had written the complaint. There's point number 1. Where's your complaint? Sorry, in 83.
Page number 33. This was the complaint to the district council.
Yes. Undisputed. Stop. Yeah. Yes. Stop. And in this regard, it is seen that the acting Lingdo, one Paiberlin Palyar, had lodged a complaint with the said authority, so an objection with said authority against the auction under market. Examination of the matter, it is clear that the dispute has arisen with regard to the auction of market is linked to the larger question, which involves the suspension of the erstwhile chairman of the management committee, D. Lingdo. Stop. Be that as it may, though the dispute does not concern the writ petitioner, the matter being concerned with the settlement of a market and the same involving disputed questions of fact, whether in fact the competent authority as given in regulation would be the best forum before which the petition of grievances filed by the respondent number 1 through the acting filed by the acting Lingdo or any other person be asked. Stop. Next paragraph. Without adverting further to the facts and without delving to the merits of the case, it's directed that the matter shall stand relegated to the Executive Committee who shall then place a matter before the executive member in charge markets for adjudication. Stop. It is further provided that till such time the matter is decided, status quo shall be maintained with regard to the management of the markets. It is also further provided that the writ petitioner shall maintain proper books of accounts with regard to the tolls so collected to be produced before the said authority.
Yeah, ma'am.
Yes. Matter only stands disposed of. Yes.
Some time frame. 1 month.
Yes. It is expected that it's expected that should we give a date for you to appear before the executive member?
Yes.
The next paragraph, the party put notice to appear before the executive member in charge markets on
5 weeks, a week from now.
On
5th August, Lord.
5th August 2024. Stop at 10:30. The Learned Senior Counsel for the KHDCs also to advise these. It's also to inform the said authority accordingly. It's further expected the matter shall be thereafter explicitly disposed of, preferably a period of 6 weeks thereafter.
Lordship, I have a suggestion.
Yes.
That 10 a.m. may be kept at 12 noon.
Why you can't get up at EM?
No, you don't know.
At 10:30 a.m. Yes.
Lordship, only the observation may be made that whatever findings that your Lordship has passed, that will not affect the...
Yes, whatever whatever views expressed in this case shall not influence the adjudication of the matter in any way. Matter stands disposed of. Market is held once a week.
Item 11.
Yes.
Lordship, here I pray for time, Lordship. There was some mistake in the affidavit. I sent for correction, Lordship, to the authorities, Lordship.
Yes, file.
No, Lordship, this matter we just received instructions.
I'll file it, Lordship.
Okay, further 2 weeks' time. Aspect can't respond to file affidavit list after and so on.
12.
That's what I Where's the impleading petition has been filed? Impleading petition. It's already been filed. Your objection?
My Lord, I have a limited scope to object because.
Then we'll implead them.
My Lord, however, I would like to make a small submission, my Lord. The application itself, the contents of the application and the prayer, is very confusing, my Lord.
Why?
Ambiguous, confusing. Let me just read a prayer, my Lord.
Yeah.
Under the circumstances, it is therefore prayed that your Lordship may be pleased to implead the Rang Bakur. Here, Rang Bakur is a representative adult male of the head clan of Tangkyolai Pok, namely Shri Asingroy, Shri So-and-so, Shri So-and-so. Now, Shrimati, now a female has been named. Then, lastly, the headman. The headman is not the Rang Bakur, my Lord. And the females cannot be the Rang Bakur. Very confusing. So this is not the way they should come before the court. It should be clear. What do they want from the court?
May I reply, Lordship?
The reason? Do you implead the clan members finish?
Lordship, please kindly come to para number 3 of my application seeking impleadment, Lordship.
Yes.
The reason being because why the annexures in the writ petition, those are annexure 2, 3, 4 and 5. These are correspondent with the government have issued some letters to me and also to some other party.
No, he has me a pointed submission. He said the implead Rang Bakur and you made women as Rang Bakur.
No, these are the Rang Bakur according to us.
Clan elders are Rang Bakur.
Sorry?
Are they clan elders or Rang Bakur?
Rang Bakur.
The big difference is clan elders and Rang Bakur.
Yes, I understand. They are Basan and Rang Bakur.
Can you correct this?
Yes.
Then you make it clan elders.
Then the headman as well, my Lord.
Yes.
Headman can't be the Rang Bakur.
Kindly come to annexures, Lordship. Annexure 2, 3, 4 and 5, Lordship. That is at page...
No, forget about the annexures, man.
It's just that he's just making a technical objection as well.
No, why
okay, take down.
The reason, Your Lordship, is because...
We'll allow the application, you implead them.
Okay, thank you.
No need to further the arguments, yes.
Yes.
This case number 124/2024 will WC 160/2024. Yes. Stop. In this application for impleadment, this case and so on, certain persons, as given in the prayer, have been sought to be impleaded as on the ground that the unnecessary parties probably as submitted by Mr. S. Marpan. Next paragraph. Mr. C.H. Molong, a plaintiff one before, whoever has raised objections with regard to the way the prayer has been given, has been styled, inasmuch as he contents Rang Bakur cannot include females and the headman. Stop. Will be sought to be impleaded as respondents 5, 6, 7, 8, 9, 10, 11 respectively. Stop. Stop. The court's given due consideration and observe that the objections are mere technicality, as the persons given there apart the headmen appear to be clan elders. Accordingly, for the general justice, the opposite parties are hereby given. Where have you given the names? The
names in the
opposite parties number. There will be number from 1 to 7.
1 to 7.
1 to 7 is going to cause title are impleaded as response number 5, 6, 7, 8, 9,
10 and 11.
As they being clan elders, and number 7 being the headman of Umsej. What's this? What's the name of the village?
Umsej.
Umsej
village.
Then how you spelled it also?
UMSIEJ.
SIENJ.
UMSIEJ.
According to this case allowed, registry to make the necessary additions in the court title. Are you appearing for them also?
Pardon, my lord?
Will you appear for them or notice has to go?
No, my lord, I don't know them.
The main case, in view of the...
Meanwhile, let them file the amended petition.
In view of the order made and so and so, this petitioner to take step which notice to the newly added respondents in the amended petition is. They'll add it and you.
Pleasure.
13.
Please, Your Lordship. Lordship, this is the matter where the Deputy Commissioner has stopped the construction of the school. Lordship, here we are in the midst of settlement. Now, Lordship, the matter can be closed subject to what my learned friend says. We have proposals that respondent number 6.
Respondent number 6.
If they agree that...
Who number 6 you are?
Adeline. She's the landowner, Your Honor.
Okay, what do you have to say?
So, Your Honor, in this matter, we have met. First round of negotiation have already taken place, Your Honor, where we have agreed to settle the matter.
Yes.
And now what is left is that, Your Honor, just for us to work on the terms of settlement.
Then
tomorrow we are meeting.
When can you settle it?
Tomorrow we are meeting again,
Yes,
actually, Your Honor.
as parties submit that the talk settlement are going on, this is a matter of the 3 weeks. Wait
3 weeks will be good enough.
Yes. Agreeable to that, Mr. Shulai?
Lordship, let us see the terms, whether it will affect the state or not, Your Lordship.
Yes.
And also, Your Lordship, in this matter, we have given some proposal to the government also to consider. This is a representation dated 11 June.
We'll see. You first settle between you, then Mr. Shulai will settle both of you.
14.
Much obliged.
Yes. Where's the affidavit?
May I please, Your Lordship? I will wait 2 weeks' time, Your Lordship.
2 weeks' time, you already give instructions that he was hurt
Yes,
and
Your
you
Lordship.
showed
We
the
have
paper
sent the
also.
affidavit, but we haven't received, Your Lordship.
Yes.
Lordship, this is the term of the Gaubra is only for 6 months. So 1 week may be given time, Lordship.
1 week, no. The thing is that your allegations that you never heard, but the district council said that you were very much present in the meeting. And you
Let them
come
file the
before court
affidavit,
with a
Lordship.
false case. You file it. Yes, Mr. Hassan.
My
You're the headman.
My lord,
Yes.
my lord, I'm for the respondent number 5, my lord. My lord, the record last occasion the JCTC council has produced is supposed to file through an affidavit.
Yes.
That's it, Your Honor.
Once you file it, you can close the case then.
No, Your Lordship, we have sent the affidavit, Your Lordship, but
Send where?
to the Tura, Your Lordship.
Yes, for the 1 week's time granted for affidavit as allowed by order dated 2/7/2024.
15.
Much better, Lordship.
Last, Lordship.
Please, Your Lordship. Lordship, the matter is fixed for affidavit, Your Lordship.
Yes. Where's the government? Mr. H. Abraham. No representation we have said yes.
Lordship, we have to receive instruction, Your Lordship, on this matter.
You haven't received instructions?
Yep, yes, Your Lordship.
Who's for the government? Nobody. None appears state respondents. And they must call a MSE pass out for 5 days for the 2 weeks for the time. Yes.
Hearing. Item 20.
Did I leave the matter?
Actually, Sir Datta, he is about to come today personally, but the senior counsel had personally informed him that his mother is seriously sick, sir.
What is your name?
Arshan Shayan.
Yes, sir. This is the matter after 2 weeks on request of the parties. Because Mr. Paul is not here. Yeah.
You're right. You're blessed.
21.
Yes, Mr. Pandit.
Yes, my lord, I am appearing for the petitioner, along with Bishop Pandit.
Yes.
So, my lord, the petitioner here is the daughter of a deceased person who was working as Daftari in the AG office for Shillong.
Yeah.
So, after his death, he submitted an application for compensatory appointment, but that was rejected without citing any reason. Accordingly, she approached this honorable court. Then, honorable court, after hearing the party, directed the concerned authorities to re-examine the matter and pass necessary orders. So after re-examining the matters, they have passed an order that she is not entitled. And the order
entitled.
Not
entitled.
And the reason not entitled. And the reason they have given in page 47, my lord, edition 10, 11A.
Page 47.
47.
Yes.
So in paragraph 3 of the rejection, it says, my lord, however, as there is an earning member in the family and your family is entitled to receive family pension at the enhanced rate till 11/2/24, and there are no liabilities in the family, the competent authority in headquarters office has not accorded approval for your appointment on compensatory ground. So this rejection was made after a screening committee had submitted a recommendation for her appointment. The screening committee was constituted by the authorities with the Deputy Accountant General, Establishment Administration, and Deputy Accountant General, Establishment 1. So in their recommendation at page 40 of the affidavit in opposition, page 40 of the affidavit in opposition.
What affidavit? Affidavit or additional affidavit?
Affidavit in opposition by the respondent.
Page?
Page 36.
It starts from page 36.
This is the proceedings, you know.
Okay.
Yes, proceeding of that committee, my lord.
Okay.
So at page 39, my lord,
yes,
of this proceeding, my lord, at paragraph 10.
Page 39?
37.
Yes.
37.
37.
Yeah.
Paragraph 10.
Yes.
It said the welfare officer also reported that the only source of income in the family pension and that the family has no immovable property. The welfare officer further reported that the financial condition of the family is very bad with a hand-to-mouth existed. In this regard, the committee was informed that the terminal benefit received by the family of late Shri Kedarnath Joshi and the normal family pension of rupees 3,500 per month. And then it further goes on to say, as per the record submitted by applicant, Mrs. Lakshmi Joshi and welfare officer report, the applicant's education qualification is 10+2 and her date of birth is 9/4/1986. Further, the welfare officer reported has stated that the applicant is unmarried as the date of verification on 2017. The committee also examined the revaluation sheet and noted that the total score in respect of Mrs. Lakshmi Joshi is 95. It is also certified by the committee that the candidate is neither related to any member of the screening committee for compensate appointment for Group C post, nor they are interested otherwise in the candidate. Taking into consideration the information provided by the administration in the foregoing paragraphs, the welfare officer's report and the Honorable High Court of Meghalaya orders for reconsidering the case, the committee recommends that Mrs. Lakshmi Joshi, daughter of Mr. Kedarnath, may be considered for compassionate appointment to be put to the post of clerk against the existing vacancy during the period from 1/4/2017 to 33/2018. This was the recommendation, and as for the scheme of compassionate appointment, if there is a difference of opinion in the recommendation committee and the authority, then it should be forwarded to a higher authority. It cannot be just thrown out like that.
Who's the higher authority?
I think it is signed by the Deputy Accountant General, so it should go to the Accountant General.
It should go to the Accountant General.
Yes, ma'am.
Where's the rejection order? Is that page?
My writ petition, page number 47. That copy. In the last slide, it says how. Yes.
I just want to see one thing, whether
25.
Is this, oh no, this is, he's a senior deputy accounting general who issued impugn order, audit, and the one who welfare was administration. So why is there a clash in, why is there a clash in opinions between the senior deputy accountant general audit and senior deputy accountant general?
So it's the same only, it's the same.
It was made by 3 persons, my lord. It was made by 3 officers, and only one officer sitting there and decides that no, I will not accept this. So in such type of situation, it should have been given to the accountant general for a decision. He cannot take a decision against 3 persons, 3 to 1.
Lordship, if you come to my additional affidavit.
What does it say?
Lordship, this is a letter addressed to the Accountant General Audit. This says that I am directed to refer to your letter number so and so, dated so and so, for reconsideration of the case. The additional affidavit, Lordship. Second additional affidavit.
You filed 2 additional affidavits?
Actually, we filed 2, Lordship, yeah. The one with dated May 2024.
One is filed on 29 February 24. One is filed on 27/4/23.
The May one, Lordship, the May.
3 affidavits filed. The third one, the last one.
The last one.
Yes, Lordship.
Filed in May.
Yes, Lordship.
Okay. Yes.
Here it's written, if you, Lordship is there, I am directed to refer to your letter number so and so, dated so and so, for reconsideration of the case of Lakshmi Joshi for appointment on compassionate ground by relaxing the norms where there is an earning member in the family, which was required to be considered as per the Honorable High Court of Meghalaya. It is stated that as per the scheme of compassionate appointment issued by so and so, dated so and so, an application from the dependent family member of the deceased government servant for compassionate appointment may be considered if the family is indigent and deserve immediate assistance for relief from financial destitution. In the case of Lakshmi Joshi, daughter of so and so and so, the family is entitled to receive family pension at an enhanced rate of so and so till so and so. There are no liabilities of the family. There is an earning member in the family. Further, no compelling reasons have been brought out to relax the norm where there is an earning member in the family, Your Lordship. So this is the finding of the higher authority. And Lordship, if you come to...
Where is written higher authority?
I mean, this is the letter which has been rejected, Your Lordship, on the ground that there is an earning member in the family. Lordship, if you come to...
then it's very strange. Let's go back to that...
proceeding.
That
Page number 36.
That is in...
Come to the proceeding also, Your Lordship.
Yes.
If you there at paragraph number 7.
Okay.
Page 37 of my...
Yes.
Lordship, this paragraph number number 7. The committee was formed as per the service book of late Kedarnath Joshi. The family members were shown as follow. Maya Joshi, she's the wife, Your Lordship. She is receiving a family pension of 20,000 plus. Number 2 is Deep.
Already. She's still there.
Yes, Your Lordship. She's receiving a family pension as on date 20,000 plus. Number 2 is Deepak Joshi. He is the son, Your Lordship. He deserted his family. He left his family, Your Lordship. And number 3 is Lakshmi Joshi, who is the petitioner. She is a class 12 passed student. And the last one is Kiran Joshi's son. He is a central government employee. Your Lordship, here what I want to point out is the 2 sons who are very much liable to take care of the mother, which eventually they did not. So now they're telling us to make us answerable for this, Your Lordship, by granting them appointment, compassionate appointment.
Paragraph 8.
What about para 10?
Yes, para 10, Lordship, that is my finding. That is the finding of the selection committee. So this proceeding was forwarded to the higher authority, and the higher authority has issued that letter where they have found out that her case cannot be considered, Your Lordship.
No, I don't understand one thing. She said that Maya Joshi, when did she die?
She's still
She's
alive.
still alive, Your Lordship.
Then?
Daughter has applied for complaints.
Lakshmi Joshi is staying with whom?
With the mother.
No.
Now she's
Yes.
married, Your Lordship. Because in the last occasion it came to light, she's married.
In 2020 she married. But as per the scheme, married or no married, will not make any difference.
No, I don't understand. Where's the scheme then?
Scheme it's
very confusing.
Scheme they have
stay with the
enclosed
mother, and the mother is getting the family pension.
Yes.
She's getting.
The scheme they have enclosed, Your Lordship, in their affidavit only. Paragraph number 18, Your Lordship. Dependent family members defined.
Page 18.
18. Dependent family members, it has been defined daughter. Married or unmarried, it is irrelevant. C. Son also, even if son is married, then also he is entitled, even daughter is married. Then you will see paragraph number 25.
So here doesn't say like that, Lordship. Daughter, including adopted daughter.
Yes.
Does not say married or unmarried, Lordship. It's silent.
If a son can get, then daughter. If married son can get, then daughter also.
Where married son?
It's not
son.
silent.
Son, Your Lordship, son always they get. So daughter also, there is no discrimination.
So, but the marriage part is silent, Your Lordship.
No. Then Your Lordship, 25, page number 25.
Read this para 11, page 23. Now to see where's the provision where if there's your mother's already getting family pension, where you're eligible to get this family pension also. And that provision I want to see.
In every cases, family pension.
Let's see that here. I mean,
So here 11 is also clear, Lordship. Only in deserving cases. Now, it's already more than 10 years that the incumbent employee has passed away, Your Lordship.
What do you want to show on 25?
Yes, my lord.
What do you want to show on page 25?
25, Your Lordship, clause D, paragraph 13, clause D. It says that recommendation of the committee, which they have enclosed here,
Now okay,
should
fine.
be placed before
They've
the
sent
committee.
it. They've sent it already, correct? Or they have not sent it. What's your case? Now he's sure that that communication showing has been considered by the higher authority. Whose authority? Who's the competent authority?
The CAG only, Your Lordship.
Who?
The Controller and Auditor General of India, Your Lordship.
Is that correct, Mr. Siddiqui?
Yes, sir.
He's a CAG, is a competent authority?
Yes, yes, Your Lordship. That is the
Well, it
highest
says that-
authority.
Well, this page number 13, it says, recommendation of the committee should be placed before the competent authority for the decision. It was placed before the competent authority for decision. Thereafter, if the competent authority disagree with the committee's recommendation, the case may be referred to the next higher authority. So there is a disagreement between the Secretary General and it is signed by administrative.
What about this letter? A competent authority, this annexure 5. 16.
So that letter means it is first.
No, this is earlier. No, sorry. This is earlier. How many times went for reconsideration?
No,
Once they
first
rejected?
it was a steering committee, then it came to committee for recommendation was placed before the officer. If officer disagreed.
Okay, come
So
back to this
is
Arisa affidavit.
next.
Now, this is the one. Who sent this letter? This is CAG letter.
CAG.
8/1/2018. Okay. So,
This is after the proceeding, Lordship.
this is after the proceeding. So, this is not a decision of the competent authority.
Office
No,
of the
this is first decision. But the law, here the scheme says if the competent authority disagrees with the committee's recommendation, that is screening committee's recommendation, the case may be referred to the next
higher authority.
So
because
this is the
in
order.
2006, Lordship, in 2016 also we have issued this impugn order which they...
About that, I'm talking about 8/1/2000. What is the purport of this order?
This is the competent authority, and next higher authority is also there, it seems. So which they have not done.
As per my knowledge, this is issued from the Office of the Comptroller and Auditor General of India. So this is the...
You get just one line instructions. Who is the competent authority as per
Higher
the
competent
the-
authority.
Just get that, we'll take it up and dispose it of.
Okay, Lordship, I'll do that.
Yes.
As there's a confusion with regard to who would constitute the competent authority under, where is that?
Scheme 9. Oh, sorry, Lordship, sorry. Scheme 13, paragraph D.
Under?
Scheme 13.
Clause
What scheme 13? No. It's called?
Clause 13D.
Under clause 13D of the scheme for
13.
compassionate appointment. Mr. Kikamfang to obtain specific instructions this after 1 week is matter lingered long enough.
24.
Oblige,
If
Lordship.
that is coming to 30, then it's finished.
Yes, Lordship.
If that's not it, then you might have some other thing.
Oblige, Lordship.
My Lord, this writ petition is filed by the casual workers of the Nehu. Well,
Same one connected to other ones?
This is regarding payments.
Yes.
My Lord, we initially when they engage us, and every 3 months they extend, and there was no deduction also. And now from 2011 onwards, they have issued appointment for 89 days after notional break of 1 day. And they started deducting the salary from the petitioner. Now, primarily, they are equipped with that issuance of 89 days appointment, though they work throughout the 90 days. Now, may I take, my Lord, the few appointment letters. If I take Lordship to Annexure 1, page 23.
What are you praying for here?
One.
Is he a prayer?
My prayer, man.
Excuse me.
Page number 19.
So the cost 2011 order?
Yes.
What's the deducted amounts according to you?
My Lord, by this resolution or letter, they have given the appointment of 89 days only, earlier 90 days. So notional break up 1 day. We are agreed with that. My Lord. And in view of this letter, 2011, it is a recurring course of action they are still affecting. Therefore, we are challenging this. The letter is the first prayer, and second prayer is, my Lord,
Where's the order? Annexure 1.
My lord. No, Annexure 1 is my appointment. Appointment letter. My lord, Annexure 1. So initially, my lord, like this one of the petition number 17, their appointment was, my lord, for 7 months.
Where?
But page number 23.
Yes.
My lord. The sanction of the officer on special duty Nehu Shillong is hereby conveyed to the engagement of Srimati and such as cleaner in the zoology department Nehu on daily wage basis at the rate of 130 of minimum scale of such plus DA for with effect from 5/1/1990 to 22nd/8/1990 until further orders. So this is one of the engagement of the petition number 7. Now similar engagement was made. Now I will not drop a. May I come to the extension? They used to extend. May I come to page number straight away. 67. 67.
How many petitioners are here?
20 total. 21. 21 petitioners. Now page number 67. This is the extension. That in continuation to this department order of even numbers and such, approval of the registrar is hereby conveyed to the extension of the term of Sri Sanjay Surung, casual laborer in this university for such for a period of 3 months. So normally they 3 months, and there was no deduction also. Now this was continued to others also.
Deduction meaning?
Well, what they do, initially now they fix the salary, so there was no deduction. They used to pay, so long as the 90 days appointment was there. But from 2011, they started deducting. Though I worked throughout 90 days, but the appointment letter says that I engaged for 89 days, and there is a deduction. Now, with that, page number 71.
Then everything's on the basis of your appointment, then how can you claim for that?
But this, I have grievance with that 89 days appointment. And then I will cite one judgment for Lordship appreciation. Page number 71. This is the letter, my lord. With reference to your letter and such, pay commission dated 31st/3/11 on the subject, I am directed to inform you that the Vice Chancellor has given order in file number and such to clear the payment of wages of casual laborer on actual days basis without 1/6 days additional payment for the month of such. Now here, my lord, we are engaged for 6 days, 6 days in a week, plus 1 day pay off. Well, 1 day pay off. That is the policy of the government of India also. So they used to receive this. Now by this letter, they say now, now we work for 6 days in a week. Now one day payment we entitled, it is taken away by this letter. By this letter.
Actual day basis when you work, if you work 6 days, should be actual days. Actually, it's appointment.
Yes. Now my actual appointment is if I am appointed for 6 days, plus 1 day, payment will be there. So I used to receive 7 days wages.
Okay, you receive payment without any cut for a Sunday.
Yes, 7 day wages.
Okay.
That is the policy. Now by this letter, they have taken away. If I work for 6 days, I entitled for 6 days only.
Yes.
Now there are 2 categories of employees. Okay, I come to further. In view of this letter, page number 72, subsequent extension order, Lordship, can you see? Approval of the Vice Chancellor Nehu is hereby conveyed to the term of re-engagement of the following casual laborers attached to the security set on the such and such, with a great payout rupees such and such, pro rata basis for a period of 89 days, with effect from such until further orders. Now earlier they used to give us 90 days. Now by virtue of this 2011, they have reduced to 89 days. But my working remained the same. There are 2 types of employees I have. One group, they are working in the department.
Have you represented against this?
One of the petitioner, yes, page number 73. One of the petitioner placed the grievance before the.
What happened?
With regard to that, My Lord, there is no formal order issued by the university to respond to his grievance.
Yes.
Now, so my grievance is, my Lord, limited. There are two types of casual employees are there. One is working in the department. Suppose one person is posted in the exam cell, exam department. They work from Monday to Friday. One category. Second category is that they are engaged in the essential services like security, cook, the electricians. They work throughout. No holiday for them. Sunday also, national holiday also, they work. They continue to work. Now what they do is that by introducing 1 day notional break, they are depriving they start deducting the few salary. Now this is the grievance we express, and the NIPU did not formally dispose of that grievance letter. And after we filed, they have filed an affidavit. In that affidavit, my Lord, the counter may just invite Lordship attention to the counter affidavit filed by NIPU. No, para 5, they say that break in service, they are admitting that yes, there is a break.
Yes.
Para number 5. Yes. Para number 5, they stated that with regard to amendment number 5.6, the repetition that answering deponent state that the same matter of record, petitioner had been engaged as casual workers on daily wage basis depending on the availability of works to meet the needs of the institution, and their engagement were not against any sanctioned posts or vacancies. While appointing the petitioners even on a casual basis, the procedure prescribed under the constitutional scheme of the public appointment was not followed. The petitioners have not been serving continuously as there were breaks in their services. Hence, the claim of the petitioner that they have been working for 20 years with breaks in their engagement is totally false and misleading. Further, it may be noted that merely because a temporary employee or casual wage worker is continued for a long period of time would not make him entitled to be absorbed in regular service or any other benefits. In this case, the petitioner have been fully aware about the terms of their appointment, and therefore they have continued in their work as per the term of contract. Now, would not have grievance against the same. Well, now, para 6 is relevant, my Lord. With regard to para 7 of the impugned letter 20 March 11, providing for clearing the payment of wages for casual laborers on the basis of actual days of work is totally justified and in accordance with law. And in any case, the content of the said letter has no bearing in the instant case, and therefore, seeking judicial review of the order is totally uncalled for. The impugned orders have been replaced by Order 15 June 2011 as per the said order. In case of casual laborers working in 5 days a week, an additional payment of wage for 1/6 of the total numbers of the days the casual laborers actually work in a month be made to him with effect from such. As stated earlier, the petitioner have not been paid their wages as their appointment clearly spell out their engagement orders. Contingent content above matter. So this is, and para 7 they admit that yes, engagement is only now 89 days. 89 days. And para 9 say that deduction, there is no deduction. So since there is a break, there is no deduction. Now, I have filed my rejoinder respond to this. Before I go to my rejoinder, may I come to page number 8 of the same in the counter affidavit, NIPU affidavit. Now the impugned order which I have challenged, they say it is replaced. May I read, my Lord? In pursuance to resolution adopted by the Executive Council in census 24/5/2011, the Vice Chancellor is pleased to order that in the case of casual laborers working in the 5 days week, an additional payment wages for 1/6 of the total number of days the casual laborers actually work in a month be made to them with effect from such and such. Now,
what does this mean?
Now, what they mean is the earlier order. They say that if I work for 5 days, I am entitled for 5 days only. Now, by this subsequent letter, they said if I work for 5 days, they will give me one day wages. So for 6 days, they will give, not for total 7 days. But my initial appointment is for holiday, or 4 week, 90 days, right? 90 days, including the holidays and the Sunday, is a casual workers. Now, by this letter, they say that if I work for 5 days, I am entitled for 6 days wages. If I work for 6 days, I am entitled for 7 days. 7 days. So those who work for, my lord, those who work for 5 days, they say that we indicted for 6 days. Now, I have filed a short rejoinder with regard to this. Before I place a decision, my rejoinder I filed on 27 February 2024 after obtaining information from NIHU through RTI. Now, I put up the RTI from the NIHU to ascertain what is the actual terms of my engagement. So I put up my RTI, Lordship kindly, page number 9 of my rejoinder, Annexure 1. So this is my RTI reply. Then they have given the information, and now information started from page number 12 onward. And important
what
one.
Is this RTI? Where's the query?
My query, my lord, page number 9. May I come to para 1? Copy of the Act, rules, or OM, or notification, or instruction, or guidelines, or order framed and issued by the competent authority.
What's the reply?
My lord. Now they have given reply page number 12. Oh, not. Page number 12. And they have given us the copy of the OM, which is the basis of my engagement. Page number 13 onward.
Yes.
My lord. And this OM is important, my lord. But this OM is issued on 7 June 1998. And the NIHU said this governed my engagement. Now, if I start from, my lord, Roman 1, point number 1. The nature of the engagement. May I start from the recruitment of casual workers and persons on daily wages, review policy. The policy regarding engagement of the casual workers in the central government offices has been reviewed by the government, keeping in view the judgments of the Supreme Court delivered on such and such in the writ petition filed by Sri such versus Union of India, and has been decided to lay down the following guidelines in the matter of recruitment of casual workers on daily wage basis. 1. Persons on daily wages should not recruit for work of regular nature. Recruitment of daily wagers may be made only for work which is casual or seasonal or intermittent nature, or for work which is not of full-time nature, for which a regular post cannot be created. The work presently being done by regular staff should be reassessed by the administrative department concerned for output and productivity, so that the work being done by the casual workers could be entrusted to the regular employees. The department may also review the norms of staff for regular work and take steps to get them revised if necessary, considered necessary. Where it is important, where the nature of work entrusted to the casual workers and regular employees is the same, the casual workers may be paid off at a rate of 1.30 of the pay at the minimum of the relevant pay scale, plus dearness allowance for an hour of 8 hours a day. They have given us this 1.30. In cases where the work done by a casual worker is different from the work done by a regular employee, the casual worker may be paid only the minimum wages notified by the Ministry of Labour or the state government or union territory administration, whichever higher as per the Minimum Wages Act. However, if the department is already paying daily wages at a higher rate, the practice could be continued with the approval of the financial advisor. It is important, my lord. Casual workers may be given 1 week pay off after 6 days of continuous work. But it is important, my engagement. So I work for 6 days, then they have to pay for 7 days. Now, the payment to the casual workers may be restricted only to the days on which they actually perform duty under the government, with the paid weekly off as mentioned at para 6 above. They will, however, in addition, be paid for a holiday, national holiday, if it falls on a working day for the casual workers. So this is the, my lord, may I come to page para 14 and Roman 11. It says, if a department wants to make any departure from the above guidelines, it should obtain the prior concurrency of Finance and the Department of Personnel and Training. All the administrative ministries, departments should take a review of and appointment of casual workers in the offices under their control on a time-bound basis, so that at the end of the prescribed period, the following targets are achieved. Now, this is the policy guideline for my engagement. Now, NEHU has adopted a resolution in page number 17, my lord, referring to this letter. Page number 17.
Yes.
My lord. But may I repeat, in pursuance to the decision of the 62 Executive Council meeting such and such, the Vice Chancellor is here pleased to order revised wages of the casual worker persons on daily wages employed in the NEHU as per the instruction on review of policy and recruitment of casual workers on daily wage basis issued by the Government of India Sansads. Government of India, that one, 7/6/1998. Now it says the full-time casual workers and person on daily wages will be paid revised wages at the rate of such with a work of 8 hours daily, no increase. Now, all such part-time and workers engaged on contingency basis are to be paid wages on broader basis. 3 is important, my lord. The wages will be restricted only to the days on which they actually perform duty. They will, however, in addition, be paid for national holiday if it falls on working days. They will be entitled for one paid of subject to continuous days of work in each week. So this is on the basis of the OM only. Now, before they issued that Impleading Order 2011, they adopted this resolution, page number 18. The type copy is 18, my lord. Originally is 18A. Where is the type copy, my lord? In view of the perhaps the VC like to place the matter before the EC, where the proposal to pay such workers an additional 1/6 of the total number of days they actually work, as this is not provided for in the rules. The EC decision would be sought for pro rata casual employees and purely daily wages casual employees to pay them or propose at such a matter. The casual laborers engage in essential services, namely water pump operators, electricians of maintenance cells, kitchen staff of hostels and guest house, etc., jokitars, securities, drivers and bus conductors, attendants of transport, safaiwalas and garbage lifters of estate are most utilized by the concerned controlling officer for the whole month without any week off. So the whole month, there is no holiday. And here now they are not paying. We are engaged for whole 7 days. We can say whole week, whole month, but they are paying for the actual days of working. That is, my lord, 6 days or 5 days. Now, number 12 is, my lord. However, in order to streamline the process, it is necessary that a performance certificate be prescribed in a proper format, and the number of days work should be specified in attendance register to be maintained by the controlling officers. Now, when I come to the the last part. My noting for page search based on assumption that the principle of 7-day payment for 6 days work applies in 5 days week also. Since it is clear that Government of India rules do not allow it, the same may not be applied. In view of the above, let the finance clear the bills for March on actual days basis without 1/6 days additional payment, since this part is against rules. So by this letter, my lord, they said they have taken, if I work for 5 days only 5 days. If I work for 6 days, 6 days. Now, for assuming, my lord, for those who are working for 5 days, they indicted for 6 days. But now, those who are working for throughout 7 days, but they are also not getting.
Losing 1 day.
They are losing 1 day. They are losing 1 day. Losing 1 day. And, my lord, to show that we used to regularly attend the offices, we also obtained the attendance register from NEHU and page number 20 onwards. Page number 20 onward. At the bottom, my lord, Mr. Kharpuri, his repetition number 2. He's engaged in the essential services. There is no holiday for him. But just to show, my lord, to satisfy, my lord, in page number 40, my lord, 44, serial number 8, Carmonate, my lord, she was posted in the exam center, and she worked for, my lord, Monday to Friday. The signature, my lord, serial number 8, P. Carmonate.
Serial number?
Serial number 8. She is the repetition number 3.
My God, yes.
So they will not, who will not dispute also, it is their own attendance register sheet only. Now the extension order, may I show with Lord's permission, page number 68.
Our rejoinder?
In my rejoinder. Now what they do, my Lord, the
68.
68. Page number 68.
68 is still the chart.
No, my Lord, 68, annex. A charge ended in 67.
This chart.
Well, after the charge, my Lord, next to the charge.
Okay, also no, there's a court petition, sorry, yes.
So my Lord. Now, order dated 16 February 2023. This is the way of extension. Approval of the VC Nihu Shillong is hereby conveyed to the terms of re-engagement of Ms. Kharpuri, casual laborer of maintenance cell, 8 hours duty a day at the rate of such, for a period of 89 days, with effect from 14 to February 2023 to 13/5/2023 until further order. So this is his 89 days appointment, though he worked 90 days. Now his extension order, Lordship, can you see page 69? Another extension order. Now another extension order issued on 7/7. Now it says approval of the VC hereby conveyed to the term of the appointment Mr. Kharpuri, such, with effect from 89 days, with effect from 16/5/2023. Now earlier, this page number 68 appointment, his appointment was came to an end on 13 May. 13 May. Page number 68.
It starts again on 16/5.
Yeah. So yes, now his extension started from 16. So after a gap of 2 days. So they removed 2 days and they reappoint me. Now I'll place one Supreme Court decision that whether introduction of this notion of 1 day or 2 days break is permissible in the eye of law or not. Supreme Court held that, my Lord, it is impermissible. My Lord, may I've given the list, 1992, volume 2 ACC, page number 28. So may I, my Lord, refer to para 3, 4, and still 6, my Lord, is relevant, my Lord. Page number, my Lord, page number 26. I'm sorry. Page number 28, stand corrected.
It is very one short judgment.
Also, page number 29, yes. Sorry. Page number 29. Page number 29.
Yes.
And relevant para 5, para 3, 4, 5, and 6, my Lord. May I read, my Lord? Yes. Permission. Para 3, my Lord. What is surprising is that till today the state has not been able to bring out comprehensive legislation on such an important aspect as education and appointment, selection and promotion, transfer, payment of salary, etc. of teachers is regulated by the government orders issued from time to time. Since 1980, it is governed by an order issued by the Education and Youth Services Department of the State of Karnataka on October 3, 1981. Clause 5 of the order reads as under. Any appointment for a period of 3 months or less in a college shall be made subject to the approval of the director within 1 month from the date of the appointment by the management or such authority as the management by order may specify in that behalf. Such temporary appointment may, however, be continued for a further period of not more than 3 months, with 1 day's break when selection through the selection committee is likely to take time. The director may, for reason to be recorded in writing, refuse approval for the said appointment, and the services of the person so appointed shall be terminated forthwith. Appointment for more than 3 months is to be a regularly consulted selection committee under clause 4 of the order. But if it is for 3 months or less, then the appointment could be made by the management under clause 4 subject to the approval by the director. It could be continued for a further period of 3 months if there was a delay in regular appointment. But the direction to reappoint with 1 day's break is not understandable. If the intention was to differentiate between the appointments for more than 3 months and others, it was a futile exercise. That had already been achieved by providing 2 different methods of selection, one by selection committee and other by management. Distinction between appointment against temporary and permanent vacancies of service law. It was unnecessary to make it appear crude. If the purpose was to avoid any possible claim for regularization by the temporary teachers that it was acting like a private business, house of narrow outlook, then the government of a welfare state. Such a provision cannot withstand the test of arbitrariness. That is why the High Court in such and such a pilot, along with many other petitions by order July 3, 1990, criticized such practice as pernicious. The rule-making authority lost sight of the fact that such policy was likely to give dominance to vested interests who leave no opportunity to exploit the educated youth who have to survive even at the cost of 1 meal a day. That is apparent from a continuance of these teachers for 8 to 10 years, with squad of termination hanging on their head, ready to strike every 3 months at the instance of either the management or the director. Provision of stopgap appointments might have been well intended and may be necessary as well, but their improper use result in abuse. And that is what has happened on a large scale. The helplessness expressed by the state in the counter affidavit that management went on continuing such teachers without holding regular selection despite orders of education. True, but not convincing. It sounds like surrender in favor of the private management. Another obnoxious part is the emoluments that have been paid to the temporary teachers. The order provides that teachers should be paid a fixed salary which is 10 rupees less than the minimum payable to regular employee. This method of payment is against beyond comprehension. An appointment may be temporary or permanent, but the nature of the work has been the same, and the temporary appointment may be due to exigence of service, non-availability of permanent vacancy, or a stopgap arrangement till the regular appointment is completed. Yet there can be no justification for payment a teacher so appointed a fixed salary, not adopting a different method of payment than a regular teacher. Fixation of such emolument is arbitrary and violative of Article 14 of the Constitution. The evil inherent in it is that, apart from the teachers being at the back and core of the management, are in danger of being exploited, as has been done by the Management Committee of the State of Kerala, Karnataka, who utilized the services of these teachers for 8 to 10 years by paying a mega salary when probably during this period, if they would have been paid salary to this, paid according to this salary payable to regular teacher, they would have been getting much more. Payment of nearly 8 months' salary by resorting to clause 5 and that to fix amount for the same which is performed by regular teacher is unfair and unjust. A temporary or ad hoc employee may not have a claim to become permanent without facing selection or being absorbed in the accordance with the rules. But no discrimination can be made for same job on the basis of method of recruitment. Such injustice is abhorrent to the constitutional scheme. 6 is important by law. While depreciating direction by the government to break service for a day or two and paying fixed salary to a temporary employees, we must condemn the practice of management of not making regular selection.
The other latest decisions also, Mr. Chareso,
Madam.
with regard to the break in service.
Madam.
Yeah, latest decisions also.
Okay.
You must have found them. Notional breaks.
Notional breaks. Madam. These are 3-bench judgment, madam.
Yes, there are the other judgments also.
Yes.
This is 1992.
1992. At the bottom point number 1, Supreme Court declared that a notional break is illegal. And similar, more or less, the 2013, another High Court judgment.
Yes, this
for persuasive.
See that?
It's a persuasive judgment.
Oh, same lines.
Yes, Punjab and Haryana High Court. My lord, para number 3, the next page. My lord, the short question involved is as to whether a notional break of 1 day can be read to the burial of the petition to reject his claim. Law that the notional break at the instance of the employee is well settled, that has been repeatedly depreciated as unfair practice at the hands of the employer. The petition was working as a daily wager with the respondent, thus was not in a position to avoid such breaks, and there is no allegation that the said notional break was owing to the fact that the petitioner was not willing to work. Thus, the petitioner is held to have continuously worked from sunset with the respondent, and he is held to be entitled for counting of the same period towards the terminate benefits in sunset. So this one also, my lord. But though this relate to fixing up the terminate benefits, the authority denied the involved the 1 day break. But the High Court said that the 1 day break, notional break, is illegal. So terminate benefit should be included, 1 day break also. So my humble submission is, my lord, the introduction of 1 day break, 89 days appointment is illegal. This is my main grievances. Second point is what is we claim for deduction.
So we say it's illegal, that means have far-reaching consequences.
Yes.
All the other departments.
Well, so Lordship is pointing at the latest judgment I need to.
Yes.
Well,
So what this court saying is that in this writ petition, you're only asking for refund of that 1 day.
my lord, that is my grievance.
Basically.
First is, my lord, my so long as I'm continuing.
It's your bigger prayer that this 89 days of employment is impermissible.
Yes, that is my first grievance.
Your prayer is there.
Yes, that is because of the eyes.
So that then what will happen to you if the order comes that's impermissible? You'll be terminated.
But
because everything stems from your upon order.
Yes.
Whatever rights flow comes from your upon order. Correct.
That is true. That is true.
Yes.
That is true.
And so you accepted those terms of appointment. The only thing grievance you might have is with regard to that 1 day, whether the university is correct in deducting that instead of, if you're entitled to 1 day paid, yes, when you don't work. So whether what will be the impact of that? That's all. And whether you entitled refund or not. So the case is very narrow.
Right.
Yes.
Right. Only two grievances that my appointment of 89 days is illegal, according to me, in view of the Supreme Court order. And second one, that deduction of 1 day.
That's
1 day.
illegal.
That is illegal. So it should be recovered, even if Lordship do not pursue it in view of the lack of evidence as pleaded by the NEHU. My prayer is that deduction should not be continued in future. This is my immediate prayer.
Please, Your Lordship. No, but in this case, my preliminary objection is, my lord, his main prayer is, my lord, to strike down in a notification of the university, my lord, that was circulated, my lord, that was issued on 20th April 2011. In fact, they do not exist. In my affidavit, I have said, my lord, with university, what happened, my lord, initially, my lord, we used to follow 6 days a week. Saturday was a working day. But we are not following that. We have discontinued it long back. Now we have a 5 days week. Now, my lord, what my learned friend has challenged, 20th April 2011. Firstly, my lord, this has since been replaced by a fresh resolution of the Executive Council, which I have annexed, my lord, in my affidavit, which say now we are following 5 days a week. So if you are working for a 5 day, you get 1 day extra.
Where's that 5 day week? Where's that notification? That is at page
8. Page 8 of my affidavit, NEHU affidavit. May I read out, my lord? 15 June 2011.
Yes.
April, May, June. In pursuance to the resolution of the Executive Council adopted by such and such 156 meeting on 24/5/11, the Vice Chancellor is pleased to order that in case of casual labour working in 5 days week, an additional payment of wages 1/6 of the total number of days of casual labour actually worked in a month be made to them with effect from the month of March 2011. So this is coinciding with the, my lord, our move to 5 days a week.
No, see, just read something personal, so the Vice Chancellor is pleased to order that in the case of casual working a 5 day week, does it say that henceforth be 5 day week?
Well, we switched over to 5 days. That's why, my lord, this changes. Otherwise, we would have continued with what my learned friend has challenged. 1/6 day. Now, my lord, initial, my lord, objection is, now this is of 2011, my lord, and this case was filed in last year, your lordships, 2023. Now, in my affidavit, my lord, I have categorically taken a stand at paragraph.
No, they'll not be entitled at all. That's out of question granting them
13 years.
refund for them.
13 years delay. 13 years delay, my lord. Well, this court's consistent view, my lord, so the delay, my lord, will defeat, my lord, the claims.
Your case,
normally consistent view of this court. No, but there is a dilemma. 13 years is a long
You
time.
appeal against that, what happened?
Well, no, appeal, I think it has been dismissed.
Didn't succeed.
Okay. No, my lord,
sleeping over your rights is one of the main things.
those
for denial of
judgment,
relief in
I
restitution.
rely on that judgment. Lordship has also relied, my lord. I have that judgment also, my lord. I rely the delay. So, my lord, there is a substantial delay, my lord. Now, my lord, coming to other thing, my lord. admittedly, Lordship has got it. Now, whenever we issue an appointment order, my lord, any employee, either he will accept, once he accepts, he is bound by the terms and conditions laid down there. He cannot accept the appointment and tomorrow, after long 13 years, come and challenge, this is arbitrary. Now, my lord, my learned friend is referring to a decision of 1992. Now, situation has changed after Uma Devi. Thing has changed. The artificial brag, my lord, I remember, before Uma Devi, in any, my lord, sanction post, that was pertaining to sanction post. They are making stopgap arrangements.
Forget Uma Devi. See, 92 was a case Pyara Singh.
Lordship.
Pyara Singh said that, if you work for 240 days continuously, you're entitled to recognition. That became bad law. Then Pyara Singh was, yes.
We did so many cases before that.
Yes.
Any, 2 years, artificial brag, exploitation of labor, we used to scream before the court. And court would intervene.
That's why I was asking the
thing has changed after Uma Devi.
That where is the latest decision regarding notional break?
No, now it is no more there.
Because Pyara Singh was, it was being placed. And I was surprised the other day in this court,
yes,
someone
92 after.
Someone was trying to place Pyara Singh.
They used to call it artificial brag, exploitation of labor. But situation has changed, Now, situation has altogether changed, so this has no relevance. And otherwise, if your lordship look into the context of this case, regular pays, sanction posts were available, but they made stopgap arrangements of teachers, pending selection. So that will not apply here.
Is that fine? Coming to the crux of the matter,
Lordship.
Where is it you saying that you have resorted into 5-day week? Where is that?
It's a 5 days a week.
Where is that? Where's the notification? See, in the case of these people, in the case of appointed for 5-day week.
No, 5 days a week, my lord, this.
And if their attendance shows that they've been working for 6 days, 7 days, how do you reconcile that?
Well, my humble
that will amount to exploitation.
No, my humble submission will be, my lord, once the conditions are spelled out in the appointment order, you are bound by it. You cannot complain against it. You just cannot complain against it, my lord. And that has been issued, my lord, long back, your lordship. Time to time it has been extended. Now after 13, 14 years, coming and challenging, this is exploitation, my lord. That will be wrong, my humble submissions. And my lord, so 5 days in a week, my lord, this following the switching over to 5 days a week, this has been issued. So in case of 5 days, 1 day of extra you get it. So that's it, my lord. And this is not even under challenge.
It says that in the case of those casual workers who go to 5 days, that means there is a case of other casual workers going 6 days.
Many will be there. Many will be.
Where does it say that? Where do you say that categorically that henceforth the resolution of the university is that all casual workers are appointed on a 5-day week and allowed extra day paid? You does not say it.
Lordship, if I can read.
Although it has not been challenged.
Paragraph 6. It's not challenged. Normally it should have been challenged. The crux of the issue now switched over to that subsequent notification. It has changed because he is relying on the old notification which stands superseded. No, entire thing, my lord, depends on this.
Even then, see, question of seeking to set aside 2011 at this stage.
My lord, after for 13 years.
No, that Mr. After knows very well. But
this will have
forward all his cards, whatever he has in his hand.
Ramification, my lord. This is a general notification, my lord. This will have a large. Now, 6, my lord, what I have said, paragraph 6, that with regard to the statements made in paragraph 7 of the writ petition, the respondent states that the impugned letter dated 23/11, providing for clearing the payment of wages of the casual laborers on the basis of actual day's work is totally justified and in accordance with law. In any case, the contents of the said letter has no bearing in the instant case, and therefore seeking judicial review of the said order is totally uncalled for. The impugned order dated 24/2011 have since been replaced by order dated 15/6/2011. As per the said order, in case of casual laborer working 5 days a week, an additional payment of wage for 1/6 of the total number of days of the casual laborer actually work in a month be made to him with effect from March 2011. As stated earlier, the writ petitioner have been paid their wages as per their entitlement clearly spelled out in the engagement order. Contention contrary to the above are incorrect and hence denied. So, my lord, there are two things lordship will note. My lord, whatever we have done as per the terms and condition of the appointments. And again we are saying, my lord, as per the actually they work.
Yes.
Now, my lord, paragraph 7 also relevant, your lordship. That with regard to the statements such and such, the respondent state that the engagement order has been issued for 89 days, and the writ petitioner were fully aware about the nature of the engagement, and therefore, having accepted the terms and conditions of the engagement, they could not have grievances against the same. It may be stated that the writ petitioner have been paid their wages as per their lawful entitlement. Actually, they worked. My lord, 89 days, my lord, they were fully aware. It's clearly spelled out in their appointment order. They know what are the consequences. They have never challenged. They have accepted it. And we have made the payment, my lord, taking into consideration, my lord, the condition in the appointment letter and on the basis of actually the work rendered by them.
Yes.
My lord, the 8 also, my lord, I'll read it. With regard to the statement made in 11, the writ petitioner reported reiterates the writ petitioner have been paid their wages as per their entitlement in accordance with the terms and conditions contained in the order. Therefore, the contention, the deduction from the salary is totally observed and not tenable in law. So, I know where from he is saying, I don't know, my lord, they appointed for 89 days, my lord. The number of days they worked, my lord, we cross-checked, verified, my lord. And then we have made the payments. Now, my lord, my learned friend, he is referring to the office memorandum. Now, office memorandum, my lord, this has been passed taking into consideration that this is meant for central government. Central government department where there is 6 working days. 6 working days, my lord. Now, my lord, subsequently EC Lordship will appreciate EC is the highest decision-making body of the university. Now, EC in the 2011, my lord, they have taken a decision. So, since it is a 5 days week, my lord, that you are entitled for extra 1 day, not for 7 days.
Okay. Anything else?
And my lord, coming back to the decision my learned friend has referred to from the Punjab High Court, my lord, that is also, my lord, out of context. That is with regard to some terminal benefits. That is obviously against some kind of sanction post. Now here, my lord, what happened?
We allow Mr. Chandra to look for a notional break.
My lord, even here, my lord, even if they continue, my lord, there are other cases, my lord. Yesterday, one case has been filed on 20 years, my lord. Have been
Where
working
has been filed?
20 years, my lord. Yesterday, I think.
In this court?
In this court, your lordship. I made a prayer that matter may come up for admission hearing. Now, my lord, similar cases were filed by the casual workers, my lord, with break and all. So this was decided. They sought for regularization, of course, in those cases to regularize their service, my lord.
Yeah.
So that has been, my lord, answered by this court already, my lord. And some appeals were preferred, appeals were withdrawn. So, my humble submission, my lord, what my learned friend is saying on that 92, my lord, that became obsolete after, my lord, Uma Devi and all, my lord. There is no question of regularization, and these are not permanent posts.
No, they're asking for regularization. They're asking for only, they're saying that
refund.
For the amount of days you worked, give us the money. That's all.
My humble submission.
Plus the extra bonus day.
Well, my humble submission, my lord, it is very clear. My learned friend, what he is referring to office memorandum of central government, though initially it was adopted by the university, subsequently, my lord, depending on our need, my lord, that we switched over to 5 days week, we passed a fresh resolution, and he has not challenged that resolution even.
Challenge it, Mr. Shah. Too late in the day, both of 2011.
There is no resolution at all.
Anything else?
Yes, this is a resolution. My lord, it's clearly say that on the basis of resolution.
Anything else?
That order clearly say on the basis of the EC resolutions, yes, passed in 146th meeting held on 24/5/2011. This is an order, my lord. This is based on EC resolution. This is just not a. So my humble submission, what my learned friend has referred to office notings of the VC and all, these all stand superseded by the EC resolution. They are the competent authority to take a call in the matter. So my humble submission, my lord, one thing is delay, other thing 5 days a week. Now, considering all those things, my lord, these do not call for any interference.
Yes. Yes, Mr. Chandra, anything else?
But my short reply with regard to delay, but my humble submission is that it is
How you see it continuing wrong?
It is a recurring cause of action. Every month, my lord, I am denied.
You're asking for refund of 1,011.
My lord, refund me of the delay. I may not be entitled for refund.
And after the resolution dated 15 June 2011. Now where they've clarified every 5-day week, annual on bonus, that means whatever rights accrued from that time stops there.
My lord, we were not aware of that 2011 EC resolution.
That's what. That's where you actually seal.
Yes.
So because that's the thing. Because whatever rights are accrued by the earlier one, it has ended.
Yes.
That's the thing.
Through RTI, we came to know, and that resolution itself is, my lord, contrary to OM, and OM is very clear. Lastly, my lord, if any department wants to differ,
but then they are central government. For them, it's up to them to.
My lord, but it is governed by the OM. They do admit it. They have given us through RTI.
They have resolution otherwise.
And the last point is, my lord.
What is the point of autonomy? How much autonomy do they who have? Can they decide? Can they have policy decisions which run contrary to OMs?
No, where your lordship has got it, my lord. This is meant for central government. We are not central government. My lord. It's central university, but we are. What happened? Any, my lord, scheme, any office memorandum, my lord, beneficial to the employees. What do we do? It is up to the university. They may or may not adopt it. They may with modification. Now, admittedly, at one point of time, we have adopted it. Now, subsequently, what happened, my lord? That resolution I am referred to you. That has been undone. That has been undone.
That stands in the way. Because that brings about a new sort of chapter in the manner which you are treated. You allowed an extra day as claimed, but your claim that you work for 7 days a week, and so not allowed that. And when by that impugned order, impugned resolution, going to 1/6, that means you're deprived of 1 day.
Well,
but that's gone now. Now that's gone superseded by the next resolution.
My lord.
So the rights that you got from there now also.
My lord. Assuming, my lord, assuming that EC has adopted that resolution correctly, now that will deprive the first category of casual workers, those who work for 5 days, Monday to Friday, they're entitled for 6 days only.
Yes.
Now, who is not answering? Those casual employees who are working throughout 7 days, they're not paying.
He's answered that. He said that you might have worked for even.
That amounts to exploitation.
5 hours in a day.
That amounts to.
But then your government terms of engagement.
Actually, they work. That amounts to exploitation, madam. That is why, madam. That's my humble submission.
Anything else to submit, or you want to?
Judgment 1992. The latest judgment, Lordship is pointed out. I'm yet to go through.
No, latest. There are many judgments regarding notional breaks, and in this case, you have a look. We'll give you another chance, since it looks like a hopeless case.
But if Lordship give me,
do the research.
Yes. If Lordship give me 10 days time, I'll look at the latest judgment regarding this notional break.
The latest judgment.
Yes.
Obligation.
Here at length, Mr. Chanay, so please allow some time to receive instructions. Yeah. Otherwise, delay on
26.
Well,
obligation.
Your Lordship, I pray for some accommodation in this matter.
Yeah, W. Rumbai.
Yes, Your Lordship.
Who's your senior?
R. Guru.
MS Lingua is ready with the file.
But he had to leave the
You don't have the file with you?
No, Your Lordship.
You don't know what's the case about?
Maybe.
You know? What's the case about?
Service matter.
Yes, the service matter. What regarding what service?
Regarding the improvement of
Regarding? Yes?
pension of the petitioner.
He's retired.
Yes, Your Lordship.
When
He's
did he
getting
retire?
his pension, Your Lordship, in
2009.
2009.
Now it's 2009. So you've come in 2023.
He's getting his pension, Your Lordship. They're
Asking for the amounts.
Yes, Your Lordship. Which
Some
he has
increments
received.
not given.
Your Lordship, as per their claim, he's not received his area increment from 1985 till the date of his
2009.
yes. But as per our affidavit, we've already paid half, Your Lordship.
He has not paid anything. You don't know anything. Yes, as the conduct counsel is not available, this matter 2 weeks. Yes. Next week you argue it. Okay. Next time, right?
I'll try, Your Lordship.
Yes.
Obliged, Lordship. Second.